we are going over the new supplemental memorandum about about this juror number 15. Juror number 15, who all of a sudden is the reason why we should overturn this verdict. We're going to look at the motion, the law, another case from the Supreme Court of Virginia that kind of dealt with this issue, and we'll see what the odds are that this is going to work, that they're going to be successful at doing this.
My name is Nate the Lawyer. If you are new here, we talk about the law and the facts. If you're about that life, don't forget to like this video, share this video, and subscribe to the channel.
All right, so here is what we are talking about, the supplemental motion. Let's start here. So Amber Heard and her team filed a post-trial motion. And this post-trial motion was, it's done with every trial, right? After the trial is over, if you lose, you throw out a whole bunch of arguments to see if there's any way that your loss can be overturned. And that's essentially what they did initially. They put this motion in just to see if they can get any wiggle room. Now, here they had a whole bunch of claims, but the claims we're talking about here specifically is the claim about juror number 15. And this was it in their original motion to set aside the judgment. Here it reads, the court should investigate whether juror 15 properly served on the jury. On the jury panel list sent to counsel before voir dire, the court noted that the individual who would be later designated juror 15 had a birth year of 1945. The juror 15, however, was clearly born later than 1945. So they put this in. It says 1945. Publicly available information says they are born in 1970. Now, I do want to mention this. This happens all the time. This happens in voting. This happens with juries. This happens all the time. Where you have a junior, a senior, or maybe the third, and they both have the same name. You get a jury questionnaire. It comes to you. The question doesn't show you if it's junior or senior, so somebody will get it. They'll go, they'll do their whole jury service, and you're like, oh, we were looking for the father, not the son, or the mother and not the daughter. So this is actually a frequent occurrence. And I don't know if you guys watch some of the election cases, but in some of the election cases, this happened a lot, where you'd have someone who had died. They were like, well, how that person cast a vote? Then they found out, oh, their son cast the vote under the old person's name, but didn't cast a vote under their own name. So it wasn't like the person voted twice. The person just voted, and the state registered as the person who happened to be dead with the same name versus the younger person. So this is a frequent clerical error, and it just happens. So let's get to how they settle. So they've brought up this particular issue, which I think is fair, right? It's like, oh, we found a juror. But in that original motion, they did also add this part to it in a footnote, which I think a lot of people missed, but they did add this. So this was an original motion, page 41, it has this footnote. Ms. Heard recognizes that VA Code 8.01353 states any error in the information shown, ... the jury panel shall not be grounds for a mistrial or assignable error on appeal. So essentially, it's, you get it, and if there's a mistake, then you can't appeal it, because if the information is incorrect, right? There's an error in the information. And essentially, that's what we have here. We have an error in the information. It's interesting that they put this footnote in their own motion, so you think this kind of kills their whole argument, right? It's like, okay, well, you found an error, but that kills their whole argument. So now they've then, as of yesterday, I believe, they then filed a supplemental motion to this original motion to give us a little bit more layers of what exactly they believe happened and why this should be overturned. So let's go to that motion and just read through it so you guys can see. And I've actually pulled up a case the only case that I can find from the Virginia Supreme Court that dealt with a similar issue, and it's not really a good case for the Amber Heard team. So, defendant and counterclaimant Amber Laura Heard, Ms. Heard, hereby supplements Section 7 of her post-trial motion based on newly discovered facts and information that juror number 15 was not the individual summoned for jury duty on April 11, 2022. And again, this sometimes happens. And before we actually get deeper into this, we also have to realize that even if this is true, right? Even if you wanted the father, but the son, there's still another step to it. And whether the person was so impacted, right? Where it was just so crazy, right? Where it was, where this person willfully tried to fool the court to get in the thing. And then on top of that was just super against Amber Heard and made such a difference to this, then, that we have to have a mistrial, right? We have to have a new trial because it was just so unfair. So there's a pretty high burden certain. Even if you do have this mistake, you still have to prove or show that this mistake negatively impacted you in some way, just more than just a clerical error. And that's where you have to kind of go with this. So I'm assuming they're going to be alluding to a lot of innuendos about the juror kind of doing this misleadingly and that type of thing. And I think that's where we're going with this, right? They're essentially gaslighting us into trying to believe that this juror intentionally did this. So that's where I think we're going with this. Let's go back to it. And therefore was not part of the jury panel and could not properly serve on the jury at the trial. Therefore, a mistrial should be declared and a new trial ordered, just based off this. Virginia law provides that those jurors whose names appear in the list provided under blah, blah, blah section shall be used for the trial in cases, civil and criminal, to be tried during the term. Then they cite something else. Fairfax County explains. So they go through the law, every citizen. So they're saying, okay, so, there shouldn't be this mistake. If we call you, you should be the one. So they're going through the law, which is smart. In this case, the jury panel included an individual named blank. Right. Obviously, it's all just redacted because we're talking about a juror. Birth date, blank 1945, resides in blah, blah, blah. This means the individual would have been 77 years old at the time. They have attachments, but the attachments aren't here. The attached voter registration also lists 2 individuals listed under that name. So we do have 2 individuals residing in that same place who are eligible for jury service with the same name and now reside in the same place. Okay. So it would be different if, let's say, the junior wasn't from that area. Or let's say the junior was from, or the second person didn't reside there or wasn't capable of being a juror in that. They could have lived in New York and just been there visiting and just went to the trial. That would be enough to say, okay, well, we got an issue because that juror wasn't eligible. So right now, though, we don't have that. What we do have is we have 2 jurors who are actually eligible in that county to serve at jury duty. And the only difference between them is the age. Both individuals apparently live at the same address. So this is all important, people. This is very, very important. So we have 2 people who are legally eligible for jury service. They both not only live at the same place, but they also are above age to serve on a jury. And it seems like everything else is okay where either one of them could serve on a jury. The individuals who appeared for jury duty with this name obviously is the younger one, right? Thus 52 years old. Now this again, 52 years old is different if they were 16 years old, right? If they're 16, you can't serve on a jury. 52 means, of course, you can serve on a jury. So really, we're talking about strictly a clerical error in this thing. I'm sitting on the jury for 6 weeks, was never summoned for jury duty on April 11th, and did not appear as required by this code. Again, if we're accepting everything they're saying is true, this is obviously just a clerical error, and the wrong person showed up. But now, whose responsibility is it if the wrong person shows up and it's obviously younger than, not 77, but, maybe in their 50s, and you can't all right, this person and that person is not the same. Whose responsibility is that, right? Because that's what it's going to come down to. Whose responsibility is it for catching this particular issue? As the court no doubt agrees, this is deeply troubling for an individual not summoned, blah, 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 blah. They're pulling on the heartstrings. This is, not summons, right? Then they go into the code here. CVA code 801-353 requiring verification, and, they bold here birth date. So they sign in using their 7-digit number, zip code, birth date, right? These safeguards are in place. Now, I'm thinking they're saying this because here they're trying to throw shade at the juror saying, well, you have to verify your identity. And they're saying that this person had the 7-digit juror number, they put in their zip code, and they put in the wrong birthday. They put in, instead of putting there 1970, they put in 1945, and try to make it seem like the juror, it's him, he or she did this thing with, they were trying to get in the jury and fool the court. That's essentially what they're trying to get to. They're literally trying to fool the court. And I just don't think, I understand the argument. I understand why they're making the argument. It's just not enough, right? I mean, relied upon about the parties to verify the identity of the correct juror to ensure the process is fair, legal for all litigants. When those safeguards are circumvented or not followed, it appears to be the case here. The right to a jury trial and due process is undermined. Ms. Heard had the right to rely on the basic protections prescribed in Virginia Code that the jurors of this trial would be individuals who were actually summoned for jury duty. In this case, it appears juror number 15 was not, in fact, the same individual as the jury. Ms. Heard's due process was therefore compromised. Under these circumstances, a mistrial should be declared. A new trial should be ordered. So that's essentially it. It's really 3 pages. It's 5. The last 2 pages are signature pages, put all the attorney stuff out there. And that's essentially it. And she has this last footnote here. It says, Mr. Depp will be incorrect in contending. So they're trying to get in front of Johnny Depp's counter arguments. Ms. Heard somehow waived the argument by not raising it during voir dire. Well, yes, that's the argument you make, right? You have the responsibility of checking these jurors out. You didn't raise it in voir dire. You waived it. That makes sense. Not only were the voir dire questions ruled on in advance and the parties limited to those questions during voir dire, but the responsibility to ensure the potential jurors participating in voir dire are those listed on the jury panel rests with those individuals in the court. See this where they put see Virginia Code 801 535. This is where I think they went left with this. And we're going to see that right now. We're going to see how Elaine essentially misstated the law. And I think she purposely misstated the law. And we're going to go back to this in 2 seconds because I think this is very, very important. I want you guys to see how sometimes lawyers, they try to massage things to make them seem worse than they are. And I'm going to show you why that statement is a misstatement of the law. Key point that I'm trying to make here is that she says the potential jurors participating in voir dire or the ones listed on the jury panel rests with those individuals and the court. So it rests with just the people who are showing up, the potential jurors and the court. That's it, right? No one else has a responsibility to check these jurors. And she literally cites Virginia Code 801-353. So you know what I did? I said, well, let's go look at the law, right? Let's go look at the law they quote. They quoted it in the first motion, they quoted it in the second motion. So let's go look at the law. Just to refresh everybody's memory what we're talking about, this is their motion now, and they put here this part where it says, but the responsibility to ensure that the potential jurors participating in voir dire are the ones listed on the jury panel rest with the individuals, the jurors, and the court. And they put see Virginia Code 801-353. That's what we're going to look at. So is that a correct statement of the law? Well, that's what we do. Let's check that out. Let's check out the law. So this was from their first motion. We saw it in their second motion. So here is the actual law from Virginia. Thank God Virginia makes it so simple. And I pulled up the relevant portion. I took the 3 sentences that are relevant to what we're talking about and put it up here instead of so we don't have to read the whole thing. So here it is. Now I want to make sure everybody understands what specifically we're looking for. Whose responsibility is it to determine whether these jurors are who they say they are? At a point, it is the court, but that shifts. So let's look at it. First, this is one of the lines. It says, the first line, I put each sentence in bullet points. Upon request, the clerk or sheriff or other officers responsible for notifying jurors who appear in court for the trial of a case shall make available to all counsels of record, in that case, a copy of the jury panel to be used for the trial of the case at least 3 full business days before trial. So it says, okay, so when we get a jury panel, we give you the information on the panel 3 days before the trial, right? So you can see, okay, and again, 3 full business days before trial. So we want to make sure you got plenty of time to do what you need to do. Essentially, 72 hours. Such a copy of the jury panel shall show the name, age, address, occupation, and employer of each person on the panel. So now the law says, okay, you get all this information and you get it 72 hours, 3 days before the trial. So they had this juror's name, they had this juror's age, they had his address, they had his occupation and his employer. They had all this information about this juror 3 days before anything started. So the clerk, here it is. Now that each side, right, now that each side has this information, who is responsible for checking if the jurors are who they say they are? Here it is. Any error in the information shown on such a copy of the jury panel shall not be grounds for a mistrial or assignable as error on appeal. And the parties in the case, so that means Elaine and Amber Heard team and Johnny Depp and his team, shall be responsible for verifying the accuracy of such information. What information are we talking about? The name, the age, the address, the occupation, and the employer of the juror, right? That's their responsibility. But I want to go back because remember what Elaine said? Elaine left out that part in her thing, right? She's trying to gaslight us by leaving out that part. Let's read her sentence again to show you how deceptive it is, how she just deceptively left that part out, that it's her responsibility to verify the name, all that stuff. It's her responsibility. Not only were the voir dire questions ruled on in advance, parties limited, but the responsibility to ensure that the potential jurors participating in voir dire are the ones listed on the jury panel rests with those individuals and the court. And then she cites the law that says, no, it's not them, it's you. So it's weird because I don't know how you can do something like this where you're citing the law that says you're responsible for checking, And then you say you're not. It's the court and the juror. But no, it says right here, when you look at the law that you cited, it says, no, it's you. You're responsible because we gave you everything. Name, occupation, birthday, the whole thing. So now you're saying it's not your, but the law says it is your problem. What happens? I want to show you guys because I was like, okay, is there a case in which something like this happened before? So the best place to go, usually you go to Westlaw, but I said, let me go to School Scholar because I'm lazy, and I said, let me go check this out on Westlaw to see if anything like this has happened before. This is another case that kind of deals with the same issues, but in a different way. So this case, this is from the Supreme Court of Virginia, 1987, Caterpillar Tractor Company versus Johnny Depp. This is the case that I'm going to go over. It actually quotes the same law, has a very similar issue, and we'll go through it, and I'll let you guys judge whether or not this Elaine's argument is going to work. I'm not going to read through this whole thing, but I'll give you a quick summary of this case. All right. So this is what happened. Matter of fact, I can just read the first paragraph because it gives you a nice little factual background. In this product liability case, there were 3 trials, right? The first trial was a hung jury. Done. Then there was a second trial, and the jury found for the defendant. So the second trial said the defendant won. So then that verdict was set aside. Like in this case, right? The plaintiff said, hey, one of the jurors, which you'll see later, was corrupt. And the trial judge set aside that verdict for the defendant. Well, I'll read it here. The verdict was set aside by the trial court for alleged juror misconduct, and a new trial was awarded to the plaintiff. So the plaintiff then won the third trial, right? So defendant won the second trial. That was set aside. New trial happens. Plaintiff now wins and obtained a judgment for $250,000. What did this court do? I'm going to show you the end of this, what happened at the end, because I like kind of just get to the bottom. So what happened at the end? So the Supreme Court of Virginia said, okay, that third verdict, the one that the plaintiff won, we're going to reverse. That plaintiff didn't win. And the verdict returned in the second trial where the defendant won, we're going to reinstate that. And the judgment is going to be rendered in favor of the defendant. So they reversed and remanded. So in this case, they actually wanted it. These litigants went and did the same thing in the court. Said, hey, juror misconduct. The judge bought it, reversed, had a new trial. That new trial, the plaintiff did win. And then the Supreme Court of Virginia reversed it and said, no. The defendant won because this was not enough. Now, this is where this starts getting complicated. So what happened in this case? Well, in this case, you had the process, voir dire process, right? And you had the jurors come in. One of the jurors happened to be an attorney. And not only an attorney, but an injury attorney, an attorney who was a corporate counsel and who's done with these type of cases. But he didn't tell anybody he was an attorney. He just was like, he was just there. So then they went through the whole process. So this attorney, who's now on the jury, which nobody knew that this attorney was on the jury, went through the whole process. During one of the breaks, this attorney juror brought out some documents and papers to say, hey, what do you guys think about this? Something similar to what was going on in the case, but not really that on point. Showing them some outside information, not about the case, but just about some other cases that he was dealing with, right? Then the jurors go to deliberations, right? Remember, no one knows this is really an attorney. So in the jury deliberations, he's like, I'm an attorney, and he starts making arguments for the defendant, right? Hey, he believes the defendant. And lo and behold, the defendant wins. Okay. So now the plaintiff was like, hey, you had a you had this juror. He happens to be an attorney. We didn't know. He did, he lied to us, blah, 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 this. And in this case, the Supreme Court said, well, we got to go back to the law. And the law says it's kind of your responsibility to follow up on this, right? You had the voir dire process, and you were supposed to follow up on this, right? And determine if this person was qualified or not after we gave you all the information. We gave you where he worked for. We gave you his occupation. We gave you all this. And it's not our fault you didn't follow up. That's the reason why we gave you the information. And the law says it's your responsibility. But the judge in this case thought it was enough that they shared this information with the jurors that wasn't on point with the case, and the fact that he wasn't forthcoming, telling people that he was an attorney. So the court also said about him not being forthcoming with an attorney, they said, well, if the error would have made him ineligible for jury service, we got something. But it didn't. It didn't make him ineligible, right? So the Supreme Court of Virginia said, with all that, the fact that he did talk about, because during the case, they always tell you, don't talk about the case, don't talk about the case. So essentially, he talked about the case a little bit. So they said, you talked about the case a little bit. That's not enough. And on the fact of the matter is, you're really an attorney, but kind of hate it. That's not enough. And Supreme Court said those two things were not enough to overturn the verdict. And that's what this case stands for. So those weren't enough. Now here we have the date issue. Is it enough? Is it not enough? They're going to have I think the trial judge will have to decide it. But in this case, all of that stuff wasn't enough. Let me put you to one other point in this where I think it's even more egregious than what happened here in the Amber Heard issue. He's called the garbage comment. Yeah, he called the other side garbage. Like he was really pro the defendant here, and even said he was. There was a point in here where they listed the things that he did. A couple of jurors said they were intimidated by him because he was a licensed attorney. They felt unhappy. One juror, in fact, said they would not have agreed with the verdict but for this attorney's conduct. But the court here said, even if all of that is true, the effort to impeach has been mounted through the jury deliberations. They went 4 or 5 hours. According to this uncontradicted, each and every juror participated in full discussion of the issues, expressed opinions, and spoke what they wanted to say. Such circumstances do not justify nullification of the verdict. Even though this guy was an attorney, even though this guy was saying all this didn't justify the nullification, all this stuff that had happened. So I think this case is a little bit more extreme than what we have here. But how will this trial judge rule? It's going to be interesting. So this is probably the best case I found that's on point with this, where you do have a juror who committed some misconduct, who showed some jurors some things outside, when they were not supposed to, and all that other stuff. And the court and the Supreme Court still held that the judgment that this jury came to was good. How is that going to affect Amber Heard's case? I think we're going to have to wait and see. But I think this makes it an uphill battle with this particular precedent in this case. So at the end of the day, it's really, what do you guys think about this? Do you guys think that this is going to be overturned, especially with this precedent? And now that we know that it was their responsibility to actually go through this and figure out, and see, no, if this juror is correct or this juror is not correct, and they didn't do their own job, and now they're trying to throw shade back to the juror and to the court. So we'll see. So that's the precedent that I found. This is the situation that's going on. And moving forward from this, it's just like, will they have enough to make this thing happen? I honestly just don't know. But again, as I said before, this is more for public consumption. The juror is bad, than it is for actually, I think, trying to win. Because based on it, I'm assuming Elaine and them know this precedent. I'm assuming they've read that particular part of the statute. I'm assuming they understand what's going on, and I'm assuming this is more for public consumption, because it's like it's going to be hard. You're supposed to check, you didn't check. You were supposed to do this, you didn't do this. And on top of that, the president says, even if he talked about the case during the trial to other jurors, and other jurors said they felt pressured to coming to the wrong decision, that still wouldn't be overturned. I don't think we have that here. I don't even think we have anything close to that. We have essentially a clerical error. So we'll see. And I do like how the fact that Elaine didn't mention that it was her responsibility or her team's responsibility to check the jurors' credentials and try to put it on the courts. So that is the update with that case. And again, let me know what you guys think in the comment section. Do you guys think Elaine did this on purpose? Do you think this is intentional, or do you think they really believe they have a shot? If you're asking me, I believe their shot is small with this. I believe it's small. Unless they can show this juror intentionally deceived the court, it's going to be tough. It's going to be tough.